Okay, in this video, we're going to be talking about the concept of secondary liability for copyright infringement, or the potential for a defendant to be liable for copyright infringement that they did not themselves directly commit, but that they in some way facilitated and therefore can be liable for regardless. In other words, their own conduct didn't constitute the infringing conduct, but in some way they contributed to or facilitated infringing conduct such that they can be liable not for primary liable, liable not for direct infringement, but for indirect infringement. So the casebook asked you to reflect on the case ABC v. Arria. I thought I'd just provide a little bit of context for that so you understood what the casebook was talking about. Essentially, that case involved a company called Arria that came up with a technology that was very cleverly designed. Some might say a bit, or perhaps the Supreme Court ultimately said, a bit too cleverly designed for the purpose of circumventing the regulations governing the use of broadcast signals in relation to cable television. So a little bit of backstory, which trust me is helpful in understanding what actually took place. So obviously broadcast television, which has been around, that's the original method of distribution of television. That was available for anyone to watch who had an antenna, right? You broadcast the signal, anyone can watch the signal so long as they can receive the signal. And the way the television companies, the television broadcasters make money is by selling advertising time on the broadcast. Well, the problem with broadcast television is you have to be within range of the signal in order to get the signal. And sometimes people want to listen or watch television programming that was outside the range that they could actually receive. And so what companies started doing was making big television towers that could receive signals from further and further away, and then condense those signals or centralize those signals into cables that they then ran to consumers. And using those cables, consumers could in effect share in the use of one giant television antenna rather than having to have their own individual antennas. And by sharing that giant antenna, they could all receive television programming from signals from broadcasters that were farther away. Well, the television broadcasters didn't like that, not because they weren't making money. In fact, they were making the same, if not more money, because it was their programming that was going to consumers, and they were still selling the same advertisements to the same people, arguably with a broader reach. In theory, they should have been happy, but they weren't happy because somebody was making money and it wasn't them, right? The companies that were receiving the signals and forwarding on those signals to consumers were generating profits from providing that service to consumers, and those profits weren't going to the broadcasters as well. So they first went to the Supreme Court arguing that was infringement, that receiving the signal and forwarding it on was a form of copyright infringement in the method of arguable reproduction and certainly distribution by the company receiving the signal. And the Supreme Court ultimately ruled against them and in favor of the kind of nascent cable television companies, arguing that really all this cable system was doing was giving consumers access to a bigger telephone antenna, not actually copying or distributing, right? It was as if each consumer simply had a much bigger antenna, and that was not infringing. The broadcasters were understandably unhappy with the outcome of that case, and so they took the next alternative, went to Congress and said, "Hey, Congress, we want you to amend the law to make this infringing activity after all." So Congress actually enacted, in the behest of the broadcasting companies, Congress amended the Copyright Act to say that whatever the Copyright Act otherwise says, receiving broadcast television signals and forwarding them to consumers is infringing, and therefore you have to pay a licensing fee. Okay, whatever, problem solved. That ended up being a method for a long time for cable television companies essentially to provide programming to consumers And of course, this meant more licensing fees, which meant higher cost to consumers. Well, Arria saw this scenario and realized that technology had changed, right? And so the reasoning or the basis for this this new amendment, or this amendment to the Copyright Act, to make essentially condensing signals into cable television infringing, said that, if you're a cable company that receives a signal and then distributes the signal to consumers, then you're an infringer. Well, Arria said, aha, we have a technological way of avoiding this legal limitation. What we'll do is rely on the original reasoning of the Supreme Court opinion and just say, look, if consumers with their own antennas, rather consumers are permitted to use their own antennas to receive signals, they simply can't rely on a middleman, to receive the signals and then distribute it to a bunch of consumers. So rather than have one big antenna receiving all of these broadcast signals, what we'll do instead is have a whole bunch of little tiny antennas with one antenna for each consumer, thereby enabling each consumer to use their own antenna to receive the broadcast signals and avoid the language of the law itself. So how did Arria's system work? You can see on the left here, all of these itty bitty tiny little antennas, each one of which was assigned to a consumer when they logged into the Arria website and said, I would like to watch some TV. And that little antenna assigned to them at the moment they log in then allows them to tune in to any signal they want, which is then buffered in the cloud and sent to the consumer. The idea here is that Arria is not in the business of providing any particular programming to consumers. It's simply in the business of renting out antennas and related technology to consumers, and thereby avoids the infringement rationale because it's not actually doing the condensing and distribution itself. The consumers are doing all the work, the consumers are making the choices, and Arria is kind of like, well, consumers can use this technology however they want to. And it just so happens that they're using it in a way that enables them to receive this material, but that should be consistent with the reasoning of the Supreme Court that it's permissible to have an antenna in the first place, and this is just an antenna at a distance. That's all it is, and we're not in the business of funneling this material to consumers. Well, a majority of the Supreme Court essentially decided that was just too clever by half, and ultimately said this is essentially the same as cable television, and because it's essentially the same and it looks the same to consumers, we don't care what technology you used. It doesn't matter. You're still an infringer, and you still are in violation of this provision of the Copyright Act that was enacted to protect, arguably in some way, broadcasters from cable television companies. But there was an interesting dissent from Justice Scalia pointing out that there was no volition, as it were, on the part of Arria. Arria was not choosing what to make the antennas and the buffering systems provide to consumers. The consumers were doing that themselves. And therefore, Arria should not be looked at as a primary infringer because it's just providing technology. It should be looked at, if as anything, as a secondary infringer only. And so the question is, what do we do with this concept of volition in relation to primary and secondary infringement? Do we need to retain it, or did the Supreme Court majority opinion in Arria effectively eliminate it? Well, the Ninth Circuit reflected on this question in the Perfect 10 v. GigaNews case, one of many in which the company Perfect 10 brought copyright infringement actions against various internet service providers. So Perfect 10 was initially the publisher of a gentleman's, or rather an adult-oriented publication, magazine. You can see a cover of one of their magazines on the left there. With the gradual decline of sales in print magazines of this variety, Perfect 10 began to pivot into a new business model. Demand for their online content was not notably impressive, but they found a second life as a business by pivoting into the role of copyright troll. So basically, rather than actually selling magazines or the content from the magazines. They instead went around looking for other people who were copying material that belonged to them, copyright protected material that belonged to them without their permission, and suing them for copyright infringement, primarily looking to aggregator websites. So they brought actions against many different companies, Amazon, Google, so on and so forth. This particular action was against a company called GigaNews, which is basically an aggregator company, a form of Usenet. So basically it's a kind of platform where users can log in and share content with each other. And GigaNews just provides the platform, the users provide the content, sort of like a social media network, but somewhat differently constructed. Okay, so Perfect 10 brings this action against GigaNews, arguing that GigaNews is an infringer because its platform is in fact distributing and displaying material to consumers, specifically material that that GigaNews users have gone out and collected on the internet and are then sharing with each other. So basically, it's GigaNews users sharing photographs with each other, photographs that belong to Perfect 10, and Perfect 10 says this is direct infringement on the part of GigaNews because GigaNews is funneling this material to consumers, and because when that material is placed in the GigaNews system, GigaNews products then translate that material into forms that consumers can actually perceive and enjoy. And therefore, Perfect 10 says that GigaNews is a primary infringer, and the Ninth Circuit rejects it. It says, look, GigaNews is not making choices about what's being copied and shared. GigaNews isn't making choices about content at all. GigaNews isn't making choices about displaying images at all. GigaNews is just providing a technology that enables consumers to do these things, and therefore it's not a primary infringer. If anything, it's only a secondary infringer because it's not deciding to do the copyright infringement. It's the consumers that are making that decision. And GigaNews is just providing a neutral platform that enables consumers to use that platform for whatever kind of content they like. Okay, moving on to thinking about theories of liability for secondary liability. In other words, when the defendant is not the primary infringer, what does the plaintiff have to show in order to make out a viable claim for copyright infringement against said defendant? Okay, so Cherry Auction is a flea market. It's a flea market. It's a kind of been around for a long time in Central Valley, California, near Fresno. And basically, a bunch of vendors come to the site. They rent out stalls from Cherry Auction, and they sell a range of different kinds of materials to people who visit the auction site, the flea market location. Among other things, they sell. There's people who come to sell fruits and vegetables. There's people who come to sell furniture, jewelry, you name it. And in the 1990s, one very popular thing for vendors at the market to sell was CDs, right? So music CDs, many of which were copied and sold without the permission of the copyright owners, right? So Phonovisa and related plaintiffs are copyright owners of primarily Spanish-speaking music. It's a primarily Spanish-speaking customer base at Cherry Auction. And so there are lots of CDs of this type being sold. Phonovisa brings initially Phonovisa complains to Cherry Avenue Auction that a bunch of vendors are selling bootleg CDs, basically pirated CDs, counterfeit CDs, not the real thing. And Cherry Auction doesn't really do very much about it, or at least they don't act to stop the vendors from making these sales as aggressively as Phonovisa and other plaintiffs would have liked. And so Phonovisa takes a new tack and says, Cherry Avenue Auction, we're bringing a copyright action infringement against you. Now, Cherry Auction's defense is, look, we're not doing any infringing, right? We didn't copy these CDs. We're not selling these CDs. We're just renting out booth space to vendors, and it just so happens that the vendors are selling these CDs, but we don't know what they're selling. We don't know whether these are legitimate or not. We don't know if they're bootlegs. It's none of our business. And Phonovisa says, no, under the circumstances, we think that you are a secondary infringer because we've told you that your vendors are selling bootleg CDs and you didn't really do anything about it, right? You're complicit, right? And inaction with knowledge ought to be enough to make you an infringer. And ultimately, the Ninth Circuit agrees and identifies two different theories of secondary liability, which are very similar but related to each other and kind of rely on two different strands of potential infringement. So one, vicarious infringement, is sort of based on a respondeat superior style form of secondary liability, albeit with respect to kind of arguable agents who aren't actual employees, right? So essentially the idea for a vicarious infringement theory is that the defendant has the ability to control what the primary infringer is doing and does in fact benefit from their infringing activity. So in the case of cherry auction, right, it could control the vendors by saying, hey, you're not permitted to sell bootleg CDs. And if you want to sell these CDs, you've got to show that the ones you're selling are not bootlegs. Right. And does it benefit from the sales that they're making? I mean, arguably indirectly, right? I mean, it's making booth rental sales from booth rentals from those CD sellers, and arguably it's making more booth rental sales than it would if it didn't permit bootleg CD sales. In addition, it's making more sales of, various foods and beverages from its concession stands, and it's selling more tickets to consumers who want to come to the auction and buy those bootleg CDs, right? So there are business-oriented benefits to Cherry Avenue Auction of permitting the vendors to sell what it knows to be bootleg CDs, or at least not doing anything to control them or prevent them from doing so. Okay, the second theory of secondary liability is contributory infringement. And that's a theory that says, look, if the defendant is enabling or facilitating somebody else's primary infringement, then they can be liable for secondary infringement. And how is Cherry Avenue Auction doing that? Well, it's providing a forum that makes it easier for vendors to sell bootleg CDs, right? So by providing the swap meet format, right, and enabling people to rent these booths and have a kind of a central location for consumers to come and buy products, it makes it easier for them to sell more products, and therefore they are contributing to the infringing activity. So the Ninth Circuit essentially says Cherry Avenue Auction could potentially win on either one of these theories, and therefore they can proceed with their secondary infringement claim against Cherry Auction on both of them. Okay. And we can think about that as well, and the concept of a kind of volition and what it means to be a contributory infringer in relation to the Sony v. Universal City Studios case we talked about previously. Of course, this is about whether or not the VCR, or rather, whether or not making and selling VCRs to consumers was a potential basis for liability. The Supreme Court found that it wasn't primary infringement because VCRs could be used for multiple different purposes. In other words, because consumers could use VCRs for time shifting among other non-infringing activities, that producing and selling VCRs was not per se copyright infringing because it was a technology that had multiple potential uses, some of which, or many of which, were non-infringing. The question is whether then Sony was nonetheless secondarily liable for infringing activity committed by the consumers of the VCR. And ultimately, the Supreme Court said no, that this is not the basis for secondary liability. Sony is simply selling the VCRs. It's not facilitating the use of those VCRs for infringing purposes. Query whether Sony, in fact, knew perfectly well, at least what it expected consumers to do. Do Sony's expectations matter, right? How should we take those expectations in light of how the machines are actually used and the ultimate market consequences? I don't know, like what's the role of secondary liability? How should we think about secondary liability in relation to the purposes of having copyright protection in the first place? That's what we can talk about in class.